Interestingly, however, the matter when it came before the Delhi High Court, and finally when the Delhi High Court decided the matter in 2010, they actually clubbed three writ petitions together in deciding whether all the three could be together decided under Section 2H to be determined as public authorities or not. And the institutions that were in question were the Sanskriti School, the Indian Olympic Association, and the organizing committee of the Commonwealth Games. So all these three were brought together in a writ petition to be decided whether they should comply within the requirements of the rule under RTA Act and whether they should appoint a public information officer and provide information or not. Now, as regards the Indian Olympic Association, the Delhi High Court clearly acknowledged the fact that it is a registered society, and no doubt there is no state or public involvement in the establishment or the administration of the IOA. Right? That's completely fine. It's completely acceptable in this that sense. And the court also said that definitely it is acknowledged here that it does not receive grants as in the traditional sense or in the traditional way or manner in which grants are supposed to be given by the government. However, must be noted that the Indian Olympic Association is the national face of the Olympic movement in India. Right? Interestingly, what the IOA says, its word determines the fate of sports and sportsmen who attend and participate in Olympic events. And it's not only confined to Olympics, but also embracing, specified international events, regional meets, etc., etc. It affiliates or recognizes bodies which regulate sports that aspire to participate in the Olympics and at international events. Its approval is essential for any sport in India, continuing to be part of Olympics and in the international movement. Now, the factual position that emerges from the auditor's report, interestingly, right from the year 1995, the auditor's report were perused by the Delhi High Court, and the grant received or receivable from the central government were also taken duly note of. Right? Now, the Delhi High Court also looked into the five-judge bench of the Supreme Court in XII Telefilms versus Union of India, where the issue of BCCI, whether it's a state or not, was also taken due note and consideration for. Now, what the court said that, looking at the preeminent position enjoyed by the Olympic Association as the sole representative of Olympics, international Olympics, as the regulator of affiliating national bodies, armed with the power to impose sanctions against institutions, even individuals for that matter, if there is doping and so on and so forth. The circumstance that it is funded for the limited purpose of airfare and such other activities of sportsmen who travel for event is not a material factor. Interesting, right? So what is material is probably the kind of function role it actually plays. Funding comes later on, right? So interestingly, selection of coaches, selection of sportsmen to represent the country are more prominent in this case. The court also said that the annual reports praised by it on record also reveals that IOA is autonomous from the central government in its affairs and management and is not discharging any public function. However, on the contrary, the funding by the government consistently is a part of the balance sheet of the IOA, and IOA depends upon such amount to aid and assist travel transportation of sportsmen and sports managers alike, and it serves an underlying public function. Right? Without such functioning, IOA perhaps will not work effectively. Right? Taking into all this consideration, it was held that the Indian Olympic Association is definitely a public authority. Now, secondly, on the fact whether the organizing committee of the Commonwealth Games is a public authority or not, the material on record did disclose that the Games Committee is a society set up as a part of the commitment to the Commonwealth Games. Right? This was after the before the 2010 Games. It though had an autonomous management character, and it was not dependent on the center for its decision making. That's definitely that. But however, the committee did receive 767 crores as advance by the central government. Right? This was to organize the Commonwealth Games exclusively. And the central government had clearly released this money, and the total allocation for the Games Committee to organize the Commonwealth Games was nearly 1,780 crores. Right? So this could not be denied by the Games Committee that it had received this funding to organize the Commonwealth Games. Right? And equally, the position regarding repayment of interest is that the central government had agreed that such repayment can be from the surplus generated due to the receipt of the games. In other words, it said that the repayment was not a precondition. Right? That is what was put across in this case. The court also, interestingly, was looking at the fact of the working. How are these agencies working and whom are they accountable for? Right? Now, the organizing committee of the Commonwealth Games was in charge of housing, posting all events, and this would mean that they were completely representing the government in terms of the games being organized and the games being conducted in that sense. So it means that generally such a funding that was supposed to be given for the committee could be written off as well, right? So that is something that they could have done. So I think both the Indian Olympic Association and the Commonwealth Games Committee were undoubtedly to be held as public authority is what the Delhi High Court finally came into the conclusion. And hence, what the Delhi High Court did was they did not interfere with the order of the Central Information Commission, and they were happy with the fact that the CIC had applied its mind adequately enough in bringing about or holding the IOA to be a public authority, as the case may be. Right. Now, when it comes to sporting federations and bodies, obviously the next big question that is in the mind of everybody is about the Board of Control for Cricket in India. In short, we generally call or refer it to as BCCI. Now, for a long period of time, the BCCI has not been held to be a public authority. And the struggle to hold whether BCCI is a public authority or not started parallelly with the Indian Olympic Association, right, for a long period of time. And you will notice that some of the judgments of the CIC in the past itself did not hold the BCCI to be a public authority. However, when the matter again came up in 2018, the Central Information Commission decided that it should be brought within the purview of the Right to Information Act, because the BCCI, interestingly, is amenable to the writ jurisdiction under Article 226 and Article 32 of the Constitution of India. And with the Supreme Court's intervention in trying to bring about reforms in the Board of Control for Cricket in India through the application of the writ jurisdiction, I think the Central Information Commission was encouraged to bring in transparency and accountability, which was something that was emphasized by the Supreme Court time and again. And hence, in 2018, as you would all appreciate, that the CIC decided in a case of holding the BCCI to be a public authority. And they said that, look, the BCCI, like the Indian Olympic Association, is probably representing the country in the sport of cricket. And it has control and affiliation from state organizations. It is probably the richest sporting federation in this country. And it has a national character, and very importantly has a monopoly right on organizing cricketing events in this country. Citing the Law Commission report, the Commission said that the kind of activity that the BCCI is empowered and the kind of impact that it can have on players, coaches, athletes, I think there should be no doubt that the BCCI should be a public authority under Section 2H of the Right to Information